The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about what happens when minors inherit property in Illinois. A minor is anyone under the age of 18, and people under the age of 18 can't get property in their own name as part of an inheritance. How they receive the property depends on whether the person passing on the property had a will, had a trust, or had nothing at all in place. That's called dying intestate if there's nothing at all in place. So let's go through the different scenarios and explain how they work. First, if the person passing on the property died intestate, what will happen is a guardianship of the estate will be set up for the minor. Now, this is different than a guardian of the person, but it can be the same person who's responsible for both. A guardian of the person responsible for the health and well-being of the child until they reach adulthood. Guardianship of the estate is the person responsible for managing assets that are in the child's name. Guardian of the estate has to report periodically to the court, and basically they have the fiduciary duty to manage those assets for the child's benefit until the child becomes an adult, and then they're distributed to the child at the age of 18. If the person who passed away had a will but not a trust, the person who passed away has the power to name who the guardian of the estate is going to be if they don't want it to be the person's legal guardian of the person. And this is often the case in the case of divorce, where the other parent is going to be the guardian of the person, and the person passing away with the will doesn't want them to get all the assets, so they name that parent someone else as guardian of the estate. Alternatively, the person with the will can name a custodian and set up a custodianship under the Illinois Uniform Transfers to Minors Act. A custodianship acts awful lot like a guardianship of the estate, except there's a couple differences. One is that the custodian does not have to report periodically to the court or seek court approval of certain types of transfers, and a custodianship is terminated at age 21 rather than age 18 like a guardianship of the estate is. A distinction between a custodianship and a guardianship of the estate and a trust is that neither a custodian or a guardian of the estate has to follow the wishes of the deceased person in the way they manage, distribute, or invest the assets. So that brings us to, if the deceased person had a trust, this is a entity that can own property after the deceased person passes away. The child that's inheriting is the beneficiary, but the deceased person names a trustee that's going to manage those assets that are owned by the trust until the child reaches whatever age the deceased person wishes them to reach before they're distributed. So with the trust, you have control over how the assets are managed and invested, control over how they're distributed and when. So you can give the trustee the authority to distribute before the child reaches the age of majority as he or she sees fit for the child's benefit. You can restrict distribution unless certain things occur, like the child graduates from college or gets married or something like that. And you also don't have to have it distributed at age 21. You can set restrictions on when it's distributed. So a lot of people say they want 1/3 distributed at age 21, 1/3 distributed at age 25, and the rest distributed at age 30, so that the child doesn't receive everything at 18 and buy themselves a Porsche and then blow their entire inheritance on that. So the bottom line is that minors can't get property in their own name as part of an inheritance. There's either going to be a guardianship of the estate, a custodianship, or a trust set up on their behalf, and which one of those three happens depends on whether the person who died that's leaving the property had a will or a trust, and there's different layers of control, supervision, guidance that both the court and the person who passed away had, depending on whether it's a guardianship, a custodianship, or a trust. So if you have any questions, I know this is kind of a complicated topic, feel free to leave them in the comments section below our post at learn-about-law.com. Feel free to also leave them on the comment section of our YouTube video. Feel free to call us for an initial consultation at 630-324-6666, and we would love it if you subscribe to our YouTube, SoundCloud, or iTunes station. Thanks again for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.